So the state of New York's concealed carry law was just found invalid, and various aspects of that law was just enjoined. So let's talk about this. But real quick before you jump into this video, if you agree that the state of New York's new concealed carry laws clearly violate the Second Amendment, go ahead and hit that like button and subscribe. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing civil rights attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. As I mentioned in the intro, in this video we'll be discussing the state of New York's new concealed carry law, the CCIA, which was found invalid just now, and a preliminary injunction was issued against that new law, and the court is now halting various aspects of that law because they do in fact violate the Second Amendment. The case we're going to be talking about in this video is Antioch v. Bruen, and the update for this case is that the judge there, Judge Sotheby, just issued a preliminary injunction against the enforcement of the CCIA. Because of how this law directly violated the Second Amendment and what the Supreme Court said in Bruen, GOA filed a lawsuit against the state of New York. In the original lawsuit, the Antioch 1 case, GOA asked the district court judge for a preliminary injunction against the enforcement of this law. But ultimately, the court found that the plaintiffs here lacked standing, that they didn't have standing, so he dismissed the entire case, and effectively what ended up happening is the CCIA was allowed to go into effect on September 1st. However, in response to that original lawsuit and the dismissal of that case, GOA fixed the standing issues, they refiled the case, and it went to the same judge. Then on refiling the case, GOA requested a temporary restraining order and a new preliminary injunction to stop the enforcement of this new concealed carry law. Judge Sotheby did in fact grant the TRO, which restrained the enforcement of various aspects of the New York concealed carry law. He went systematically through the CCIA and said various things were unconstitutional, but he allowed various other things to also remain in effect. Since the TRO is a temporary placeholder, the plaintiffs here, GOA and the individual plaintiffs, were also seeking that preliminary injunction. Well, Judge Sotheby just issued a new order, and Judge Sotheby did in fact grant the request for a preliminary injunction and halted the enforcement of various aspects of the CCIA. Now, this decision is about 184 pages, so I haven't made it through it all. I've skimmed through most of it. A lot of it was kind of a carryover from what he said in the TRO and some of the original language he also had in the first case when he said that he would have actually granted the preliminary injunction if there wasn't standing issues. But I haven't made it through it all, so I'm not going to get into all the little nitty-gritties of this case. Just kind of give you a general overview of what generally he did, what parts he enjoined, and what parts he allowed to remain in effect. In this ruling, he first found that the good moral character standard is in fact invalid. One of the primary reasons was because he stated under Bruen, the Supreme Court endorsed a standard that compels a state to issue a carry license unless the licensing officer finds that the applicant is likely to use the handgun in a way that is dangerous to himself or others. He pointed out that the good moral character standard that New York was now pushing for and now had in effect was essentially the proper cause standard which the Supreme Court struck down in Bruen. He did say in this opinion that he believed there was historical support to justify an objective permitting standard, but that this is not an objective standard and that is not what New York passed. Instead, they passed a subjective good moral character standard that has no historical basis. Therefore, he granted a preliminary injunction against the CCIA's good moral character standard. Then he looked at other aspects of the CCIA as well. He enjoined the enforcement of the law requiring a list of family members and cohabitants, and the requirement that applicants provide the licensing officer with a list of social media accounts for the past 3 years. Judge Sotheby, in his opinion, found that these types of standards that the state of New York was putting into effect are the type of standards and requirements that the Supreme Court warned against in Bruen. He in fact stated that, simply stated, the court finds that this is an example of what the Supreme Court warned against as an exorbitant requirement. He then quotes the Supreme Court where they stated, "That said, because any permitting scheme can be put towards abusive ends, we do not rule out constitutional challenges to shall issue regimes where, for example, lengthy wait times in processing licensing applications or exorbitant fees deny ordinary citizens the right to public carry." So he used the language in Bruen which warned against these types of overbearing restrictions in a permit application, even if in language, in terms, it shall issue, but if the restrictions are so heavy that it doesn't actually operate as a shall issue, he said that Bruen warned against this very thing that New York is doing, and therefore it's invalid. He then looked at the sensitive place restrictions that the state of New York put into effect, and he looked at the general one, which is the big one, which is kind of the catch-all provision. He found that these new laws that have a general restriction on concealed carry in all locations, unless the property owner actually grants permission, is in fact invalid. He stated that indeed, this restriction appears to be a thinly disguised version of the sort of impermissible sensitive location regulation that the Supreme Court considered and rejected in New York State Rifle and Pistol Association v. Bruen, and therefore he granted a preliminary injunction against the catch-all provision, the catch-all carry ban, the catch-all sensitive place ban in the CCIA. Now I'm still going through some of the more specific sensitive location bans, because just keep in mind that the CCIA had that catch-all provision, but then it also targeted specific locations like churches, restaurants that serve alcohol, and some other locations as well. He found that the government controlled areas, general buildings like federal buildings, state buildings, he found that the plaintiffs here did not present an intent to carry in those locations, so they lacked standing. So he did not actually issue a preliminary injunction on those aspects of the sensitive location, but he looked at some of the other areas like the subways, parks, places where people serve alcohol, restaurants, things like that. And he issued a preliminary injunction against the enforcement of those specific sensitive locations. So some of them stood, some of these specific ones stood, and then some of those other ones were struck down as well. Now, there were also some important aspects of this law that was allowed to remain into effect, and that included the 4-person reference letter requirement and also the 18-hour training requirement. When deciding the 4-character reference requirement, he stated, "The court finds the burdensomeness of the 4-character references requirement is reasonably proportionate to the burdensomeness of the relevant historical analogs. As a result, plaintiff's motion for a preliminary injunction is denied with regard to this regulation." Now, in reviewing the 18-hour training requirement, he also found that that requirement was not so overburdensome. Now, he did say that some of the payment requirements for the training was in fact troublesome in his eyes. He said that could be troubling and could be struck down. Again, the Supreme Court warned about something being so costly that people couldn't ever even get their permit, but for now he did not issue a preliminary injunction against those aspects. So as you can see, this judgment was not perfect by any means. There were a ton of solid wins, however, and some of the bigger aspects of the CCIA were in fact enjoined. Now, in the same order, the judge also did deny the state of New York's request that he issue a temporary stay on his own judgment. He stated, "After carefully considering the matter, the court denies this request for the reasons stated by plaintiffs in the reply papers and during oral argument, and for the reasons stated recently by the U.S. District Court Judge John Sinatra in Hardaway v. Negrelli." And as you guys might recall, in one of my past videos, I talked about that case, Hardaway v. Negrelli, and I talked about that was a challenge to the CCIA's aspect on banning concealed carry in churches. And in that decision, the judge also denied issuing a stay on his judgment, finding that even letting a law remain in effect for just one day is one day too many, especially when you're dealing with an unconstitutional law, something that will burden someone's right to keep and bear arms. Even one day is one too many. So here Judge Sotheby is agreeing with Judge Sinatra and is not issuing a stay on his preliminary injunction. Now, I have no doubt that New York will actually seek an interlocutory appeal on this preliminary injunction. They will likely also seek a stay of this preliminary injunction by the Second Circuit, but as of right now, we will take all the wins we can get. So if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signal to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.